6:47 a.m. Received legal correspondence at Cheating Story Lab. Today's hearing was unexpectedly advanced by the judge. Gather all relevant materials as my ex-wife, Kendra, has filed an emergency motion alleging neglect and unsafe conditions towards our kids, plus accusations of threats when she interfered. Her demand includes full custody, supervised visitation only, and a restraining order imposing a 500 feet distance from our children. I've seen the filing, knowing every word to be false. Nevertheless, I'm aware that truth doesn't always prevail in divorce cases without solid evidence and thorough documentation. So I've meticulously compiled such evidence over the past 18 months as Carter, a logistics coordinator for a medical supply company. A job that initially seemed mundane involves me monitoring everything: shipments, timestamps, signatures, deviations from standard procedures. When my marriage with Kendra began deteriorating 3 years ago, the same analytical knack activated within me. Not suspicion, but pattern recognition, as she had become distant since our second child was born. Our daughter Lily was 4 at that time, and our son Owen was 2. After returning to work as a pharmaceutical sales rep when Owen was 6 months old, Kendra took up a position with extensive travel requirements. At first, I attributed the distance to postpartum depression, later to the struggle between her career and motherhood. However, I discovered inconsistencies in the hotel receipts that didn't align with her work calendar. I did not confront her straight away. Instead, I observed, documented, and maintained a spreadsheet detailing her travel dates versus her company's regional assignments. The discrepancies were substantial. 4-day trips to Nashville, where her territory did not encompass Tennessee, and weekend conferences that didn't match the assigned regions. Initially unmentioned Austin events left me puzzled. Upon inquiry, she broke down, revealing an extramarital relationship that she wished to mend for the sake of our children having both parents. I chose to trust her, leading us to counseling. After 3 sessions, she ceased due to a busy schedule. 6 months later, she requested divorce, which I consented to avoid imprisoning her in an unwanted marriage. However, I insisted on joint custody, aiming for a 50-50 arrangement in our children's lives. She smiled in agreement, but her lawyer later presented a proposal seeking primary custody with me receiving every other weekend visits. She requested child support based on non-custodial parent calculations and wanted authority over all medical, educational, and religious decisions. I refused this, leading to hostility. Kendra resided with her corporate regional manager boyfriend, Trevor, who appeared amiable but enjoyed golf, drove a lavish car, and sported expensive timepieces. He lacked biological children yet was eager to act as a father figure for Lily and Owen. My feelings towards Trevor were indifferent. My concern stemmed from Kendra employing the kids manipulatively, promising a custody arrangement, then an hour before pickup claiming they were ill or fatigued, or requesting mom. She'd arranged their medical appointments within my custody period without informing me, even asserting I was absent in their healthcare management. She sparked a gossip among Lily's preschool faculty that I was challenging during the separation. But in reality, I attended events while she spread the word I was prohibited from participating. This prompted me to compile evidence, saving and safeguarding every text message, printing and archiving each email. Every call logged with date, time, and summary. I adopted a shared calendar where each entry and edit was time-stamped. This allowed me to document when changes occurred, especially when she altered her plans. However, the crucial action I took was contacting the daycare. Lily and Owen attended Little Sprouts Learning Center, a facility a few blocks from my residence. Kendra had selected it due to its convenience for pickups on my custody days. Unbeknownst to her, Little Sprouts utilized a digital check-in system. Each parent picking up a child was required to sign on a tablet, which recorded their signature and timestamp, as well as took a photo for security reasons. I requested copies of the pickup records from the director, Mrs. Helen. She explained she couldn't release them without a court order, but she could verify the system's contents if needed. I mentioned that I might require it for custody hearings. "Mr. Carter," she cautioned, "I have been in this job for 23 years. Over the past years since both children joined, I have primarily taken care of them, as Miss Kendra has seldom been present." Upon my request, she provided a record of this observation. As the custody dispute intensified, I became detail-oriented and kept a diary detailing every interaction with the kids, activities, conversations, meals, sleep patterns, and even took photos of their rooms to demonstrate stable, age-appropriate living spaces. I meticulously collected receipts for all kid-related expenses, clothing, toys, hobbies, medical bills. In response to her allegations that I fed them fast food frequently, I presented 3 months' worth of grocery receipts showing the purchase of fresh produce, whole grains, and lean proteins. Photos of us at parks, museums, zoos, and libraries were provided to counter her claim that we spent our days in front of screens. Lastly, I showed the teachers emails thanking me for my involvement in Lily's homework when she accused me of neglecting it. However, Kendra held more than just proof. She possessed a story, a straightforward one. I was a resentful ex-spouse struggling to accept the divorce. My behavior was dominating, fixated, and potentially harmful. My obsession with exacting retribution for her departure had led me to arm the children as weapons. I monitored her actions, challenged her parental decisions, and made her feel frightened when in my presence, which some people could comprehend because of my tracking, questioning, and documenting. The twist was that I did it because she was deceiving, but I demonstrated this in a courtroom setting. The hearing was scheduled for 10 a.m., and at 9:45 a.m. with my attorney, the sharp-witted Patricia Morno, specialized in high-conflict custody cases, we arrived. She had examined my documentation and plainly stated, "You have enough evidence to win this case, but be ready for her dramatic performance. Tears, allegations, whatever it takes. Judges are human." They respond to emotion. "What should I do?" I inquired. "You need to remain composed, present facts," was the response. "Let the evidence lead." We stepped into the courtroom where Kendra was present with her lawyer, Brad Castillo, a young attorney known for forceful strategies. Kendra looked frail in pale makeup, sparse jewelry, and a modest dress signifying a struggling mother. Her eyes were bloodshot from crying. Trevor occupied the gallery behind her, his hand offering comfort on her shoulder. The magistrate was Honorable Margaret Reeves, a former family law attorney with a reputation for detecting manipulation. "That gave me encouragement. Let's proceed," Judge Reeves stated. "Ms. Kendra has filed an emergency motion for full custody and a protective order. Mr. Castillo, you may put forth your client's argument." Brad rose to speak. "Your Honor, my client lives in terror. Mr. Carter has demonstrated a pattern of domineering, compulsive behavior since the separation. He persistently watches over her, challenges her parental choices, and has issued warnings about her bond with Mr. Trevor. 2 weeks ago, he unexpectedly visited her residence, knocking forcefully on the door and insisting on seeing the children despite it being her custody period. The children find these encounters distressing. Given that Kendra is petitioning for this order to safeguard herself and her offspring, Kendra testified. She fixed her gaze on the judge, her voice trembling. "Your Honor, I merely wish my children to be secure. Carter has transformed since the divorce. He's perpetually enraged. He alleges that I am a poor mother, neglecting Lily and Owen. He bombards me with 20-30 texts daily, inquiring about my location, activities, companions. 2 weeks ago, he stormed onto my property at 9 p.m., pounding on the door while shouting that I was obstructing him from seeing the children. They overheard the commotion. Lily questioned me the following day if father was going to harm us. She broke down crying. I never wished for things to be this way. Despite my efforts, he proves challenging in our custody arrangement. He frequently misses pickups, cancels last minute, then shifts blame onto me when the children refuse to visit him. Last month, he skipped 3 scheduled visits without notice, forcing me to arrange for childcare at short notice. I'm drained, scared, and seek court intervention to safeguard my babies from him. Brad provided text messages as evidence, which depicted me sending urgent messages like, "Where are my kids?" and accusing him of recurring misbehavior. They appeared damaging, particularly when viewed out of context. Judge Reeves scrutinized the messages before turning towards me. "Mr. Carter, do you have a response?" Standing up was Patricia. "Your Honor, we possess extensive evidence contradicting Ms. Kendra's assertions. If granted permission, I'd like to present this evidence systematically." Proceeding, Patricia retrieved a 3-ring binder from her case. "Your Honor, Mr. Carter, the evidence shows otherwise." Carter has kept meticulous records of his custody periods, his dealings with the children, and Ms. Kendra's conduct during this phase. Let me address her allegation that he missed pickups first. In court, she presented a calendar. It was the court-ordered custody schedule, with Mr. Carter's actual pickups marked in green. As you can see, he hasn't missed a single scheduled pickup in 14 months. The 3 visits Ms. Kendra mentioned were instances where she texted him an hour before pickup stating the children were sick, but refused to provide medical documentation. Judge Reeves displayed disapproval. "Ms. Kendra, do you have evidence that the children were unwell on those dates?" Kendra's attorney shuffled through papers. "We can produce it if necessary, Your Honor. I would like to see it now." However, they couldn't produce it. Later, regarding the allegation from 2 weeks prior, where Ms. Kendra claimed Mr. Carter arrived at her home and banged on the door, that was October 14th at 9 p.m. This was confirmed by court records. Carter's designated custody evening. Miss Kendra was due to deliver the children to his residence at 6:00 p.m. as dictated by the court order. At 6:30 he texted asking for her arrival time. At 7:00 he phoned. At 7:30 his calls began going straight to voicemail. At 8:45 he drove to her residence to confirm the children's safety. He did not pound, shout, or threaten. Miss Kendra declined to open the door but texted him that she had chosen to keep the children with her for the night. She presented a judge with a printed conversation thread detailing this sequence of events. She disregarded the custody order, Your Honor. Mr. Carter acted to uphold it. Judge Reeves addressed Kendra. "Why did you detain the children that night?" She replied softly. "They didn't wish to go. That's not a decision for one person to make independently." Judge Reeves then said, "Please proceed, Ms. Moore." No. Patricia produced another document. This marked the heart of Miss Kendra's appeal. She alleges that Mr. Carter is a neglectful, seldom present father who presents a risk to the children. She has portrayed herself as their primary caregiver. Your Honor, we summoned records from Little Sprouts Learning Center where both children attend daycare. She presented the judge with a substantial printout. These are the digital pickup records for the past 18 months. Every parent who retrieves a child signs a tablet that records their signature and timestamp, as well as taking a photo for security purposes. Judge Reeves began leafing through the pages, her countenance changing. Mr. Carter has picked up Lily and Owen 312 times in the past 18 months, while Ms. Kendra has only done so 3 times. The courtroom fell silent. Kendra's complexion faded. Brad glanced at his client perplexed. Trevor leaned forward to examine the documents. Patricia allowed the moment to pass before proceeding further. The 3 times Ms. Kendra retrieved the children were the only instances documented in the past 18 months. Kendra collected the kids only during weeks of court-ordered custody evaluations, aware her parenting was being closely examined. Regular pickups fell to Mr. Carter, including days ostensibly under Kendra's custody. Judge Reeves questioned Kendra. "Ms. Kendra, how do you account for this inconsistency?" Kendra replied, "I work, my schedule is not flexible, but Carter's is." However, she had previously identified herself as the primary caregiver. Unanswered by Kendra, Patricia continued. "Your Honor, we also have Mrs. Helling's testimony, the daycare director who received a call from Ms. Kendra 3 weeks ago. She inquired if the center could lose or delete certain pickup records because they might complicate her custody case." Brad objected, "Hearsay," but Patricia remained composed. "Mrs. Helling is outside and ready to testify under oath." Introduced Mrs. Helling, who was let in, sworn in, and verified everything. She explained a detailed phone conversation with Kendra, her precise words, the tense tone, offering to donate to the center if records could be altered. "I told her it would be done." Mrs. Helling claimed falsifying legal documents. She ended the call. Judge Reeves confronted Kendra. Her voice was frosty. "Kendra, you tried to alter evidence in a custody hearing." "No, I merely misunderstood the records." "The records revealed truth," snapped Judge Reeves. "What more do you have, Ms. Moore?" "Nothing else," replied Patricia, pulling out another binder. "Financial records, Your Honor. Kendra receives $1,800 per month in temporary child support from Mr. Carter. We have bank statements showing that during her custody weekends, she hired babysitters frequently, spending between $200 and $300 per weekend while traveling with Mr. Trevor. During the custody period, the children were with paid caretakers instead of their mother. The mother presented highlighted bank statements showing regular payments to 3 distinct babysitting services as proof. In contrast, Mr. Carter has extensive records detailing every meal, activity, and bedtime story during his custody time, including photos, receipts, and journal entries. Ms. Kendra lacks such documentation because she was not present. Judge Reeves leaned back, addressing Mr. Castillo. "Do you have any rebuttal?" Brad glanced at his notes, then at Kendra and the mountains of evidence on Patricia's table. He responded, "Your Honor, my client has been under significant stress due to the divorce. She may have mistaken certain details, but her concern for the children's safety is sincere. However, every claim she has made has been contradicted by documented evidence. She lied about pickups, misrepresented herself as the primary caregiver, and attempted to destroy evidence." Judge Reeves pressed, "What basis do you have for your statement?" Kendra is utilizing the court as retaliation against her ex-spouse for adhering to the agreed custody arrangement. This is an example of unscrupulous litigation that squanders judicial resources and negatively impacts children. Kendra wept once more, yet no one offered comfort. Judge Reeves glanced at me. "Mr. Carter, do you have any additional remarks?" I rose, my hands remained calm. "Your Honor, I don't aim to penalize Kendra. I desire for my kids to maintain a bond with their mother, but I also want truth to matter. For 18 months, I've been labeled as controlling, fixated, and hazardous because I recorded facts. I kept track of events due to her dishonesty. I questioned actions because they contrasted with her words. I waged this custody battle for the sake of my children who deserve a parent who is consistent." I paused. "I adore my kids. I've been there for every fever, every nightmare, every scrape. I might not be a flawless parent, but I am a present one. That should hold some value." Judge Reeves gave a slow nod. "Every aspect is taken into account, Mr. Carter," she addressed Kendra. "Ms. Kendra, your emergency motion has been declined. Instead, I am altering the temporary custody arrangement. You will have primary physical custody, Mr. Carter. Supervised visits are granted to you every other weekend until you prove consistent, active parenting. In addition, child support payments based on state guidelines are ordered towards Mr. Carter, and this matter is being referred to the district attorney's office for investigation into evidence tampering." Kendra's mouth gaped open, but no words escaped. The hearing concluded as Judge Reeves declared. She looked at me once more before saying, "Mr. Carter, your children are fortunate to have you." Brad rushed to collect papers, and Trevor stood up and left without looking at Kendra. Frozen in her seat, Kendra gazed blankly into nothingness. Patricia whispered close to my ear, "This is the most rewarding case I've handled in 5 years." Feeling neither victorious nor content, just drained, yet there was another sensation, a sense of affirmation not due to triumph but the victory of truth itself. Stepping out of the courtroom, I phoned my parents who'd been taking care of Lily and Owen. My mother picked up promptly. "How did it go?" she asked, her voice laden with apprehension. "I have primary custody," I replied. "The judge saw through everything," my mom began sobbing. "Oh, Carter, thank goodness. Can you bring the kids to my place?" "We'll be there in 20 minutes. Upon returning home, I settled on the couch and gazed at the 3-ring binder Patricia had handed me, filled with 18 months of records, every pickup log, every text message, every receipt, every journal entry. It was evidence of my presence, but more importantly, it demonstrated that I had been vigilant. After all, deceptions crumble under scrutiny. Kendra constructed a whole narrative about me being absent, irresponsible, and dangerous. She had expected emotions to prevail over facts. She had anticipated the system siding with the emotional mother over the reserved father. However, she didn't account for the daycare's digital records or Mrs. Helen's honesty. Neither did she expect my meticulous record-keeping. Upon their arrival, my parents brought Lily and Owen. Excitedly, Lily rushed towards me and embraced, exclaiming about cookies they made at Grandma's. Behind her, Owen followed with a stuffed dinosaur in hand, asking if Daddy was home. I picked up both children, one on each hip, giving them a tight hug. "Yes, buddy," I replied to Owen. "Daddy is home." My mother hesitated at the door. "Are you all right?" I assured her. "I will be," I said. "It's just..." For 18 months, I was accused of being the problem, controlling, obsessive, even dangerous. But the entire time, I was simply striving to be a good father. "You are a good father," she acknowledged firmly. The judge recognized this too. After my parents departed, I prepared spaghetti with marinara sauce, a favorite of Lily and Owen. We dined at the table, where Lily shared tales of a butterfly spotted at preschool, while Owen playfully mashed noodles onto his face, giggling. The evening was ordinary yet ideal. Later, after baths and bedtime stories, I put them both to bed. Looking up at me with her large, brown eyes, Lily inquired, "Daddy, are you upset?" I replied, "No, dear one, I'm content being with you." In response to her query about eternity, I pledged, "Forever." I switched off the light and stood in the hallway, savoring their soothing slumber. The following day, an email from Patricia arrived. It appeared the district attorney was probing Kendra's efforts to manipulate daycare records. Her legal representation had withdrawn from the case. Additionally, Trevor seemed to have vacated her apartment during the night. "Penalties," wrote Patricia. "Occasionally, they do transpire." I moved the email to my documented closed case folder and initiated a fresh file titled Future Planning, as it was clear that the battle wasn't concluded. Kendra would appeal, regroup, and formulate a new argument. That's what people like her typically do. However, I had gained an essential insight. The truth may move slowly, but it is inexorable when one exhibits enough patience to let it unfold. And I was indeed patient. After 3 months, the amended custody order solidified permanently. Kendra's supervised visits became sporadic. She would appear once and miss the next two, citing work commitments as an excuse. The children stopped inquiring about her presence. I did not rejoice at this development. It was disheartening. They deserved a mother who was consistent, but they had a father who was reliable. Recently, Lily's kindergarten teacher requested my assistance as a volunteer for the class field trip to the Science Museum. I took a day off work to accommodate. Throughout our excursion, Lily tightly grasped my hand, inquisitively examining exhibits and chuckling as static electricity caused her hair to spike. On our return trip by bus, she dozed off against me. That evening, I jotted down events in my journal, not for legal purposes nor as proof, rather for myself, to one day explain to Lily and Owen the facts surrounding our divorce. Not my interpretation of reality, but the genuine, time-stamped, authenticated truth. I desire them to comprehend that I fought tirelessly for them, and that evidence holds significance because ultimately, it was the accumulated 312 pickup records, not animosity, resentment, or retaliation, that rescued us.